Welcome to Lok Sabha Television. This is Rajiv Kumar Singh. United States of America, one of the oldest democracy in the modern world, gave itself a constitution close to 230 years ago. In the over 2¼ century of its existence, the US Constitution has been amended only 27 times. India shortly would be entering the 70th year of its constitutional existence. And already, the Constitution of India has been amended over 100 times. So, is the Indian Constitution too flexible? Why did we need so many amendments? What did the founding fathers of the Indian Constitution think about amendments? In the next half an hour, we would look at the journey and the evolution of the Indian Constitution through its amendments. Adopted on November 26, 1949, the Constitution of India came into effect on 26th of January 1950. And it said that the Union of States, that is India, is a self-governed, independent, sovereign, democratic republic administered by a parliamentary system of governance. The words socialist and secular were added to its preamble much later. Though the original Constitution of India, being a voluminous document of over 80,000 words, which guides us on a whole lot of issues, the founding fathers knew that the success of the Constitution depended on its actual implementation.
Constitution is not merely the name of a book. It is not merely an inert document, but it is a living, dynamic process. It is always in the making, and much depends upon how it is actually worked in practice. In the Constituent Assembly on the last day, on the last 2 days, Dr. Ambedkar and Dr. Rajendra Prasad, both in different words had said that whether the Constitution proves to be good or turns out to be bad will depend upon how it is actually worked in practice.
India has the longest written constitution in the world, starting with 395 articles, 8 schedules and 22 parts. It now consists of 448 articles, 12 schedules and 25 parts. The founding fathers of the Constituent Assembly were of the view that for the all-round development of the country, constitutional amendments may be required from time to time. In order to reflect the reality of life, genuine public well-being, administrative and legislative requirement of the Constitution, a constitutional amendment could be brought using the provisions under Article 368. According to Article 368 of the Constitution, there are 3 modes of amendment of the Constitution. Amendment by ordinary law, where a simple majority is required in both houses of Parliament. Amendment by special majority of Parliament, which means vote from 2/3 of the members present and voting in both houses of Parliament. And thirdly, amendment brought by a special majority in Parliament along with acceptance of half or more of the state legislatures. The Indian Constitution has been amended 101 times. Many constitutional bills are still lying with the Parliament. Some constitutional experts feel the Constitution should not have been amended these many times.
The conclusion that we reached in that commission, that most of the reform suggestions that we talk about can be implemented without amending the Constitution. Because problem is not in the Constitution, problem is in its actual working. Most of them can be implemented without amending the Constitution and without even legislation.
However, there are others who feel that India being a diverse and a complex society, more constitutional amendments were needed.
All these amendments, if you look carefully, then these amendments are indication of the fact that Indian democracy is in the process of evolution.
The first amendment of the Constitution of India was made in 1951. The very next year, the Constitution came into effect. Apart from bringing the 9th schedule and giving the state power for the upliftment of socially and economically backward classes, It also restricted freedom of speech and expression guaranteed by Article 19(1)(a) on the grounds of public order, friendly relations with foreign states, and incitement to an offence.
The First Amendment was enabling the government to violate even equality, to violate even 14 and do affirmative action in favor of women, children, scheduled caste, scheduled tribe. And therefore, what happened was equality itself was subjected to a change. Equality became equality which is unequal because they were dealing with inequality.
Though the separation of power between legislature, executive and judiciary was well defined in the Constitution, and conscious efforts were made by the Constituent Assembly to make none of the three organs too powerful, in the long journey of the Indian Constitution, there also came a time when its very fabric came under severe stress due to the personal ambition of a former Prime Minister, Indira Gandhi. The Constitutional 24th Amendment Act 1971 enabled the Parliament to dilute the fundamental rights through amendments of the Constitution. It also amended Article 368 to provide Parliament the power to amend any provision of the Constitution and made it obligatory on the President to give his assent when a Constitution Amendment Bill was presented to him. The 24th Amendment was opposed by jurists and all surviving members of the Constituent Assembly. However, in the Keshavananda Bharati versus State of Kerala case of 1973, the Supreme Court ruled that the provisions forming the basic structure of the Constitution cannot be amended.
What is basic structure is not defined, but every court defines it in accordance with the provisions of the facts placed before it. Till now, about 30 basic structures have been defined by courts in different cases.
Indira Gandhi did not like. That is why supersession came. Not only supersession came, she filed a review petition. And you will be surprised that review petition was listed before the bench of the then Chief Justice A.N. Ray. It was argued for 2 days. God knows what happened after 2 days, that the same government decided no, public opinion is going against us, judiciary may not be able to help us, though we brought A.N. Ray, our man, he may not be able. Can you believe, till today I am saying, that petition is lying in the docket of the Supreme Court. Nobody else has even argued. That means country has accepted doctrine of basic structure, and that means constitutionalism is growing.
25th June 1975 to 21st March 1977, the period of emergency proclaimed under Article 352 was the most hectic as well as the most controversial with respect to constitutional amendments. A whole gamut of changes were brought, starting with 38th Amendment and extending up to the dreaded 42nd Amendment. The 42nd Amendment has even been called a mini constitution in itself. With the 38th Amendment passed on July 22, 1975, the judiciary was stripped of the right to make judicial review of the emergency. Though Allahabad High Court had cancelled Indira Gandhi's election from Raebareli in 1971 on ground of misuse of state machinery, the 39th Amendment was brought to maintain the hold of Indira Gandhi on the Prime Minister's chair. The 39th Amendment stripped the jurisdiction of the judiciary to investigate the election of the person appointed on the Prime Minister's post. According to the amendment, the inquiry of the Prime Minister's election could only be done by the committee constituted by the Parliament. Mrs. Indira Gandhi took refuge in need of the time of emergency to bring in several constitutional amendments during the period. After amending several provisions of the Constitution through 40th and 41st Amendments, the most controversial 42nd Amendment was passed. The 42nd Amendment established the supremacy of Parliament over all other wings of government. The fundamental rights of the citizens were undermined. Directive principles of state policies were given priority over fundamental rights. The 42nd Amendment also added a set of fundamental duties for the citizens. For the first time, the preamble of the Indian Constitution was amended by adding words like socialist and secular. The preamble also substituted unity of the nation with unity and integrity of the nation. The 42nd Amendment also added a year in the tenure of Lok Sabha and envisaged administrative tribunals as quasi-judicial body. It further imposed limits on the power and jurisdiction of the judiciary. It authorized the use of central armed forces in any state to deal with law and order problems and made the President bound by the advice of the Council of Ministers. Even to the liberal-minded, those were the darkest days, not only for the Constitution but also for the nation as a whole.
This almost was so draconian, and it led to the 1977 elections, where Janta government came into power, that no provision of this was in fact made effective till 44th Amendment came into being, and almost major portions of the 42nd Amendment were deleted from those provisions. Some provisions, of course, were kept.
The worst which happened was that certain laws which were amended retrospectively, they were put beyond the scope of judicial review by putting them in non-schedule. That judiciary cannot even question it, and that is where judiciary did not like.
The first non-Congress government of India, led by Morarji Desai, brought the Constitution 44th Amendment Act 1978 and did away with the ills of the amendments brought during the emergency, mainly the 42nd Amendment. With the passing of 44th Amendment in order to impose national emergency, the basis of internal unrest was replaced by armed rebellion. Changes in provisions related to other aspects of emergency were also brought so that it could not be misused in the future. The right to property was removed from the list of fundamental rights and made a legal right. The Morarji Desai government restored the period of Lok Sabha and state legislative assemblies to 5 years. The Supreme Court was empowered to resolve the dispute regarding the election of President and Vice President. All these provisions, in a way, reaffirm the faith of Indians in the Constitution.
Supposing in future situation arises that internal emergency is imposed, even during the period of internal emergency, right to life cannot be taken away without providing natural justice, and court will have the power to decide whether demand of natural justice has been met or not.
The Constitution 99th Amendment Act 2014 has been the latest bone of contention between the legislature and the judiciary. The amendment provided by the formation of a National Judicial Appointments Commission. The NJAC versus Collegium debate raged throughout the country. The NJAC would have given legislature and civil society a say in the appointment of judges to the highest courts. And though the act was passed by a special majority in Parliament and also ratified by more than half of the state legislatures, it was declared as unconstitutional and void by the Supreme Court. The highest court cited Article 50 of DPSP and said that the NJAC Act violated the separation of power.
NJAC, National Judicial Appointments Commission, sought to disturb this collegium, and it gave a formula where the collegium will be the Chief Justice, the topmost 2 judges of the Supreme Court, the law minister of the country, and 2 eminent persons to be decided by a committee of Prime Minister, Leader of Opposition, and Chief Justice. Now, this was construed that these 2 eminent persons may be appointees of government, and of course law minister is there, and this will encroach the judicial review, which is a basic structure of the Constitution. And on this ground, that since the appointments of the judiciary form basic structure, this was invalidated.
It's time for a short break on the program. After the break, we would know about constitutional amendments which brought far-reaching and positive changes in the Indian society. Welcome back to our program on constitutional amendments. Close to 70 years of constitutional functioning of our democratic nation has seen tens of amendments which could be termed visionary and having far-reaching effect on the Indian society. The common view amongst the experts on law is that the amendments, with a few exceptions, have strengthened the constitution and the functioning of Indian democracy over the years.
To me, it appears India's constitutional democracy has functioned very well, very well. Rather, I salute Indian constitutional democracy, and particularly the credit goes to the Constitution.
While all constitutional amendments are brought with the intent to benefit the Indian citizen, few have much more effect on the common man. In 1953, there was a big movement for Vishal Andhra for separation from Madras state on the basis of language. A separate state was demanded for Telugu-speaking people. Madras state then included Andhra, parts of Karnataka, Tamil Nadu, and even parts of Odisha. This movement led to many such movements in the country. The 7th Constitutional Amendment Act of 1956 recognized the states on linguistic grounds by abolishing the existing classification of states under Part A, Part B, Part C and Part D. The country was then reorganized into 14 states and 6 union territories. However, as things turned out, with the formation of states like Chhattisgarh, Uttaranchal, later termed Uttarakhand, Jharkhand and Telangana, language too did not remain the main criteria for the division and formation of states.
The problem of Telangana, problem of Chhattisgarh, Jharkhand, Uttarakhand, was it the problem of language? No, that was not the problem of language. Problem was what? What is now division of Andhra Pradesh? What happened to Punjab, Haryana and Himachal? They said that, look, maybe we speak the same language. Maybe they also speak Telugu and I also speak Telugu, and therefore you took language as the basis and created me one state. But what the result is, that portion is economically developed and I am not economically developed, and therefore change your basis of demarcating the state.
The 10th Constitutional Amendment 1961 incorporated Dadra and Nagar Haveli as a union territory, and the 12th Amendment Act 1962 incorporated Goa, Daman and Diu as union territory, consequent to the acquisition from Portugal. The 13th Constitutional Amendment Act 1962 led to the formation of Nagaland with special protection under Article 371A. The 15th Amendment Act 1963 enabled the High Courts to issue writs to any person or authority even outside its territorial jurisdiction, if the cause of action arose within its territorial limits. The Constitution 26th Amendment 1971 strengthened Article 14, right to equality before law and equal protection of law. This amendment also abolished the privy purses and privileges of the former rulers of princely states. The Constitution 31st Amendment Act 1973 increased the elective strength of Lok Sabha from 525 to 545. Sikkim became the 22nd state of the Indian Union by the Constitution 36th Amendment Act 1975. Another very significant constitutional amendment was the 52nd Amendment Act of 1985. which gave the provisions related to anti-defection in India. It laid down the process by which legislatures may be disqualified on grounds of defection and inserted Schedule 10th. It was brought in 1985, soon after the Rajiv Gandhi government came to power, with a thumping majority with over 400 seats in Lok Sabha. However, there are certain loopholes. As per the 1985 Act, a defection by 1/3 of the elected members of the political party was considered a merger. Such defections were not actionable against. Finally, the 91st Constitutional Amendment Act 2003 changed this.
Aaya Ram, Gaya Ram, in 2 hours, a person changed 4 parties. And that is why this doctrine came, Aaya Ram, Gaya Ram. That was the culture of defection. And that is why to meet that, that anti-defection law was brought. Of course, few people, they objected strongly. They said, look, it violates my freedom of speech. It violates my freedom of expression. And you recall, that is why it was said that, all right, if you really believe that your freedom of speech and expression is so important and you want to remain morally high, but you cannot ignore the whip. If the party has issued the whip, you must follow it. And if you want to violate it, you inform your party.
However, few experts feel that the anti-defection law needs to be further amended. Another remarkable change was brought by the Constitution 61st Amendment Act 1988, which lowered the voting age from 21 to 18 years. By the Constitution 69th Amendment Act 1991, Delhi was made National Capital Region. The Constitution's 73rd Amendment Act 1992 added the 11th schedule to the Constitution of India. It ensured direct election to all seats of panchayats. It also provided for reservation of seats for SCs and STs in proportion to their population and reservation of not less than 1/3 of the seats in panchayats for women. The Constitution's 74th Amendment Act 1992 added the 12th schedule. It ensured direct election to all seats of nagarpalikas and municipalities. The 73rd and the 74th Amendment Acts are rightly considered as far-reaching amendments which brought changes at the grassroots level and strengthened democracy.
This is the third tier of federalism. This is the third tier of parliamentary democracy. And to me, it appears the third layer is most important, because that is an indication that democracy is going down below to the masses.
Once we have a reservation of women in these grassroots institutions, it is to be hoped that the women public representatives become mature and find place finally in state legislative assemblies and in union parliament.
स्कूल की घंटी बज गई है.
The Constitution 86th Amendment Act 2002 added Article 21A and provided right to education as a fundamental right for children between the age of 6 and 14.
मिलकर स्कूल चले हम.
The changes brought in Article 45 of Directive Principles of State Policy by the 86th Amendment Act directed the state to provide for early childhood care and education for children up to the age of 6 years. The 86th Amendment also added to the fundamental duties of the parents to provide education to their child between 6 to 14 years. This act made the Sarva Shiksha Abhiyan mandatory. Many such changes were brought by the acceptance of the recommendations of the Venkat Chalaiya Commission on the working of the Constitution.
I also had the honor of being member of that commission and chairman of its drafting committee. It was appointed in 2000 and we made a report in 2002, and many of the recommendations of that commission have been implemented, which is not usually known. For example, education as a fundamental right was recommended by us. Narega, much talked about Narega, now Mahatma Gandhi's name added to it, that was recommended by the Commission. Limit on the size of ministers, that was recommended by the Commission. It was about 20 of the major recommendations have been implemented.
The Constitution 93rd Amendment Act made the provision for 27% reservation for other backward classes in government as well as private higher educational institutions. The 100th Constitutional Amendment Act deals with land border agreement between India and Bangladesh. India shares its longest boundary with Bangladesh. LBA paved the way for exchange of 162 enclaves under the control of either country. 111 border enclaves were transferred to Bangladesh with citizenship rights in exchange for 51 that became part of India. The Constitution 101st Amendment Act 2016 deals with the GST, that is, Goods and Services Tax. GST was implemented on July 1st, 2017, whereby indirect tax coming under excise, custom, services, VAT and CST, central sales tax, were made uniform throughout India under one tax, GST. In the 7 decades of constitutional life, with a brief aberration of about 21 months, the Constitution of India has guided its 3 pillars on an evolutionary path. As India gains its legitimate place in the Comity of Nations in the 21st century, it is expected that the words written some 70 years ago continue to show us the path of enlightened democracy. And any change, need there be, is brought with a view to benefit the last man standing. Thanks for watching.